The California Consumer Privacy Act is a new law that goes into effect on January 1st, 2020. The CCPA enables consumers to better understand the data that is being collected on them, as well as how that information is stored, shared, and monetized. Modeled after Europe's GDPR, the CCPA provides very specific requirements as well as penalties for companies and startups, whether they are US-based or international, that collect personal information from California residents. Internet attorney Andrew Rossow joins me as we discuss the CCPA. Up next.
I'm here with Ethan Pierce. We are talking about the California Consumer Privacy Act.
Yes, fun stuff. In a law library.
In a law library. I still have anxiety of being here. 3 years in this building, and it still gives me anxiety coming back.
I just get anxiety when they send me the bill.
Oh, God. Hey,
so
we're not all that bad.
Yes. So,
sorry.
Anyways, here with Drew Rossow. I was looking at the Facebook Live. Now I'm going to look at you. Here with Drew Rossow, who's a lawyer who focuses on cybersecurity and blockchain law and all kinds of really cool stuff. And we are going to talk about the CCPA and how California is about to make all of our lives much more complicated starting on January 1st. And to that point, maybe you'd just like to kind of dive in and give a quick idea of what the CCPA is. And then I've got a bunch of data that I can read through to be more specific about it if we want to, about what it really defines, what the penalties are, different kinds of issues. But it's really more it's more about your perspective on this. We're going to talk about it from a couple different perspectives. The CCPA in general, but there's more and more information about that. What really interests me is going to be how this affects startups, how this affects e-commerce companies, how this affects marketers, and more importantly, how this affects, with those companies, the ones that are not Californian, and even more than that, the ones that are not American. So that's where I'm going to kind of take the questions, but to at least give context, CCPA.
Well, for those who don't know, CCPA is the California Consumer Privacy Act, and that is coming into effect the very beginning of January. What this is doing is providing the United States with its very, very first privacy framework that has been modeled after the European Union's very own privacy framework that people know as GDPR. So I think, really just to get started, this is our first attempt, our being the U.S., at trying to regulate and control user data and really give the data back to the consumers, to give it back to you and I, and to make sure that we're protected with any company that we're working with in the U.S., specifically California, but any business, because we do own our data. We do have a right to our data, how it's distributed, where it's being distributed, and why it's being distributed.
To that point, then, the basic tenets of this are know what personal data is being collected about them, to know whether their personal data is sold or disclosed and to whom, say no to the sale of personal data, access their personal data that has been stored, request a business to delete any personal information about a consumer collected from that consumer, and not to be discriminated against for exercising their privacy rights, meaning equal service and price. So that's the basic 6 pieces of what this is going to lay out for residents of California. What does this really do for you as a Californian? And then, as this is going to be done elsewhere, giving you ownership of your personal data and how it's been monetized, giving you control over that data and have it removed, and giving you security by providing financial penalties if companies have a data breach with your personal information. So kind of laying out there that first bit of stuff. What should we expect as a Californian moving forward with the websites or services that we use starting in January? How is our life going to change in relationship to all of these companies that are now having these obligations like the GDPR applied on them in the U.S.?
Sure. Well, first let me ask you a question. You've checked your email recently, I would assume.
Mm-hmm.
How many emails have you seen so far where, whether it's Twitter, Facebook, Papa John's, where you've gotten an email saying terms of services have changed or terms have been updated? Have you personally seen any emails like that yet?
I've started to get a few. To be honest, I unsubscribe to practically every newsletter I can possibly find.
You're smart. You're smart. Do that.
But or I have other email addresses that collect that I haven't maybe noticed that they sent me that. But I have seen a few of the platforms that I use let me know that things are changing without necessarily saying it's this.
Right. So, and to my point, Many of you, myself included, have just started getting emails. It could be from PayPal, Facebook, Twitter, LinkedIn, whatever platform where you have at any point in time given over your personal information. This could be you registering. This could be a Fandango. Whatever it may be, you are now getting emails that are saying our terms of service have changed. We've updated our website. Please take a look. This is all in response to the CCPA. And what this is doing is setting or trying to set a standard, whether you are a law firm, a large business, a small business, or a private practitioner or an entrepreneur, to make sure you are complying with this. Why? Okay, why should somebody who isn't in California even be concerned with this law and even our video? It's a good question, because at some point you may come into contact with somebody from California or do business for some period of time, whether you realize it or not, with somebody in California. And to answer your earlier question of, well, what if I don't permanently live in California? What if I don't have a driver's license, but I travel there, I have a couple business meetings, I decide to take on a new contract, or I have a new partnership. There's activity going on. There is business going on. And right then and there, you are subjecting yourself, arguably, to the jurisdiction and laws of the state of California. This is huge because you need to be aware of who you're doing business with. And again, going back to this borderless age where everything is online, you have airlines, you have Amazon, and this goes back to Law 101 of jurisdiction. Can you sue somebody from, Florida and be in California? How do you establish that relationship? And it's what's called as the personal contacts analysis. Or do you have significant contact with the state of California to essentially convince somebody or make someone reasonably believe that you live there? And that's, again, it's going to be it depends situation. So for those people, you have to know who you're doing business with. You have to know the channels of business that you're doing. Where are your products going? Where are your videos being distributed to? And it's a very large question.
So technically what they're saying is any business that collects consumers' personal data and does business in California that has either gross revenues in excess of $25 million, possesses the personal information of 50,000 or more consumers, and importantly with the GDPR, we're going to see households.
Right.
And then, or, because it's or for these, earns more than half of its annual revenue from selling customers or consumers' personal information. So that's pretty big companies in most of these cases. How will this affect small businesses and startups who are under that $25 million in revenue or under the 50,000 customer data limit?
Well, again, you're looking at the approach. As a small business, who are your clients? Who are your customers? Who is your intended? Who is the ultimate recipient of your services? At the same time, go even deeper. As a small business, are you being funded? Are certain people investing in you? Okay, this could be somebody out in California, an angel investor, that's putting money into your business just to say, hey, go do your thing. Let's see it grow. There's still information being traded there from your investor itself. So I think it's a means of controlling and really knowing your business. It's a matter of understanding each and every person that is a part of your business, not helicoptering, so to speak, but understanding every aspect and geographically understanding what your business is doing. And that's a big problem, as you can see with a lot of these larger corporations, is they're too big. They're very big, and sometimes it's very difficult to even get a hold of the right person. And for a small business, it's tough for them to grow a business. They may be very successful in their own right, but it's a lot of work to really target the right areas of the country, to figure out what products are going to appeal to the right demographic, and sometimes that requires even consulting with people out in Silicon Valley or whatnot.
So if you are under these limits, the CCPA might not apply to you directly, but if you are a B2B startup, for example, maybe you're based in New York, but because your clients are large corporations that are above these thresholds, that's going to waterfall down to you, where you will also have to behave correctly under the
Sure.
CCPA with this customer information because you were doing it on behalf of, like an agency model, like you mentioned, or other things, a much larger company that does qualify, that does go above these thresholds.
Sure, and yes, 100%. And again, not legal advice here.
Yes,
Not
I'm not a
legal
lawyer.
advice.
He's a lawyer, but this is not.
I am not giving
not
legal
legal
advice. I can give life coaching advice. It may not be very good, but there's a doctrine in the law. It's called respondeat superior, and as you said, employer-employee agency relationship. You are working in the scope for somebody else. So in your example, where a small business may be working on behalf or for a larger corporation who then may be doing business with somebody or a group of people out in California or even another business out there, yes, you are going to be subject to it, whether you realize it or not. So the takeaway here is it doesn't matter if you're not doing business now in the state of California, comply. Absolutely make sure your website, your terms of service, your privacy policy are up to date. And if there are questions, find somebody, bring somebody on to your team, an IT professional, security professional, just for that sense.
And I think so. How we're going to see this play out, some of the requirements that we're going to see, I think the first one we're going to see a lot of starting in January is that you have to have a "Do not sell my personal information" link on the homepage with those words. So we're going to, I think, start to see a lot of "Do not sell my personal information" links starting to show up in the footers of companies everywhere.
Big, bright, bold font. So
in order
people can see it.
to know that. And then you need to have methods for data access requests. And it even, when I was reading through it, it even says including a toll-free number, which is a curious thing that could be, I think the people who sell toll-free numbers are going to make some money if all of a sudden we take this international and you have California residents that are using your service and you've got this information, it starts to get kind of, this access gets interesting, language issues, but if you need a toll-free number or other things, that starts to get a little bit heavy.
And sure,
on
now you're taking a
compliance.
toll-free number who's now collecting even more information from the people who are calling. So that's
Great.
that's another issue. But yes, you are going to start to see these changes because these companies have to protect themselves. Otherwise, again, just kind of like what we were talking with the CCPA requirements in our last video or earlier on, is you got to safeguard yourself. You have to safeguard what you're doing, and it's not worth the risk, whether you're big or small. For a small business, an oops could put you out of business. Now, and the goal of this is not, as they have said, this is not intended to put somebody out of business. Will they purposely put somebody out of business? Absolutely not. They're going to take into consideration the size of the business with respect to the scope. But this, for some, this really could put you out of business.
So in terms of the penalties, then, in terms of the risk around the data breach idea, so if they are collecting my personal information and I have not opted out of that and I have not done anything to request that be deleted or anything else, so I have this relationship with them, they have my data. If there is a data breach, then according to this, $100 to $750 per California resident or actual damages, whichever is higher, can be imposed, and up to $7,500 fine for each intentional violation of the CCPA and $2,500 for each unintentional violation of the CCPA.
I don't even have that kind of money.
Yeah, so this is going to get expensive very quickly if people are either ignoring the CCPA or if they have already poor data security and quality control internally, but even if they don't, we see very large corporations that theoretically are protecting data and still get hacked. So it sounds like there's going to be some bills to pay.
There is.
At the end of this.
And these fines, these penalties that you just listed off, they're meant to be harsh. They're meant to be exorbitant because this is all about deterrence. It's all about, we don't want you to pay the money. We really don't. It's more work for us. But if you mess up, we want to make sure you don't mess up again, or at least learn significantly. And for a lot of these larger corporations or tech giants, to them it may not be a lot of money, but it's a lot of money that is now attached to damaging information to their reputation. And once your reputation is under scrutiny, as we've seen over the past years with certain companies, not to be named, it's very difficult to gain that trust back from the consumer side. But yeah, I mean, there are factors here to consider, but they are meant to be hefty.
And this takes us actually perfect transition then into GDPR compliance. So how does this compare to GDPR compliance? If I am GDPR compliant, am I automatically CCPA compliant? And just to tie it together, one of the things that's been criticized so far about the CCPA and the penalties is, while that sounds like a lot of money, it's nowhere near the 4% of gross revenue that the GDPR can impose as a penalty.
Right.
What else? So to the first point, if I'm GDPR compliant, am I CCPA compliant?
Absolutely not.
Why?
Two different sources of law. For many, many, many years, the U.S. has looked to Europe and the European Union for guidance on privacy regulation. Why? Well, how many international companies or European companies do you read about or hear about in the news that are getting hacked, breached, or compromised? Not too many. Not saying it doesn't happen, but we're not hearing much about it. Why is that? Because the way Europe and the EU has structured their framework has been a perfect representation for their group of how privacy and how data should be contained. That is what inspired the CCPA. When GDPR came into effect, it was designed to be very harsh in terms of penalties. It was designed to deter people and say, if you mess up, you will not do it again. You absolutely will not do it again. And when it came into effect 2 or 3 years ago, Google paid the price the hard way. One of the very first companies to be hit with a fine. So GDPR is very lengthy. It is very, very lengthy. It is comprised of 99 articles that are each probably about the size of its own Harry Potter book per article. It is a lot. And within those 99 articles, Ethan, are filled with more legal obligations and requirements. What is a data processor? What does personal information mean? What do you have to do in your business to make sure you are compliant? There are so many requirements that there's absolutely no way, especially for a small business, since we're talking about that, for them to comply. But even if they attempted to comply, more likely than not, they'd be breaching, whether they intend to. So what the CCPA has done is said, hey, GDPR, perfect representation, very large, very complex. Let's expand the coverage in terms of the right to opt out, the right to say, I don't want my information shared, but dumb it down. Dumb it down into a way where there's not 99 articles, but it is a way for people to really understand it. So bring it down to earth. That's also left some questions about, well, are there issues with the CCPA as it stands? Absolutely. But the CCPA is an attempt to expand the realm of what personal information is, how you as a consumer, you and I, can ask a company or request a company to remove us from their database, the right to be forgotten, but also simplify the complexities and the legal jargon that GDPR has brought.
So then if I'm a startup or an e-commerce platform, but I've got a business that is working with other solutions like Google Analytics to track the people coming to my website, but we could also think about inbound marketing tools, marketing automation, CRMs, newsletter and emailing providers like MailChimp. We've got all these different tools that we can use that we plug into our website or our mobile app or our platform. How does this, as a small business, how will this come into play in this definition of sharing personally identifiable information? Meaning that people are using my service, but in using my service, obviously these big companies are going to put into play their own CCPA compliance, but in terms of me using, for example, MailChimp, you come to my website, you sign up for my newsletter, now am I sharing your information with MailChimp, or are you sharing it with MailChimp and I'm simply using them as a service provider? Does that make sense?
Oh, 100%. To the customer of your website, the small business's website, customer has some questions to ask. What are you going to do with my data? You're asking me to sign a contract with you. I'm hiring you to do something. What are you going to do with this sheet of paper or this form that I've just given you with all my information? Well, we're going to store it. Well, yeah, I know, but where? Who are you going to give it to? I have every right as a customer to ask those questions. And if you at any point as a small business owner or that individual I'm conducting business with doesn't feel the need to share it, that's a problem. Maybe because you have a right, you're supposed to share it, you're required to, But two, I'm not going to go into business with somebody who hasn't even thought about it or isn't willing to talk to me about that. Now, if I say, okay, all right, I understand, you've explained, you've answered all my questions, let's move forward. Now to MailChimp, now you have questions to ask MailChimp, okay? You need to go, again, above and beyond what you would ordinarily do to cover yourself. It's always a CYA, all right? Make sure you're not the one getting in trouble. I'm going to share data with you. Where is my data as a business, which includes my customers' data? Where is that being housed? Where are you doing this? Okay, where's it going? Do you, MailChimp, have a right to opt out? Meaning, do I, as a small business, have the right to opt out of you sharing my information, my business's information, which also includes my clients or customers? You absolutely do. And if there's not an option for that, it's not you getting in trouble. It is MailChimp or that organization. Just for the record, MailChimp hasn't done anything wrong here. We're not hating
Just
on
examples.
MailChimp. Just a hypothetical example. We use MailChimp
Twilio,
for...
SendGrid, all kinds of people do mailing.
We use MailChimp for Grit Daily, and most of these press outlets and news outlets use that too.
And these companies like HubSpot and Google Analytics actually do behave well in terms of
Very much
telling
so.
what they do with their data and things like that. My interest is in the language of, if I'm collecting that data, if it passes through, like with Google, I don't actually see that data collection.
Correct.
But maybe with the CRM idea, maybe I'm an e-commerce website, so I know you have an account on my website, I have your information, but I also, that information is passed to PayPal in order to provide payment. It's also passed to FedEx in order to provide delivery. There are pieces of data that are being shared. So, short answer to all of that then is, obviously all of these larger providers will handle CCPA on their own. But I need to not only do what is correct in terms of my responsibilities for CCPA, in terms of my data collection and usage, but also most likely need to be explaining that I've passed this data on to these companies, and most likely they will be giving me some boilerplate text to put into my terms of service, or I'm going to have a lawyer need to write that for me in order to make sure that I am potentially sharing personally identifiable information with these other service providers. And that means that under the CCPA, I need to be responsible for how they, or at least communicating how they are going to, that they have collected this data through me and that they are going to do what with it.
Sure, because, and that's really what it is if you lay out all the parties, starting from the consumer, the customer, to you as a small business, to then MailChimp, HubSpot, CRM, whatever company that you're working with or hiring to do your job, you need to break down all the different parties and really put it on a spectrum and analyze each and every activity that each party is doing and saying, okay, this person has now transferred this type of information over. What needs to be done as between those two parties? Once it gets to that party, what needs to be done with those two parties? So to really get at this, take a look at some of these websites. Take a look at some of these companies and see what their privacy policy looks like, okay? I can more than guarantee that most of them now have some sort of both COPPA and your CCPA privacy policies already on there. So, again, not legal advice, but look and see how some of these companies are writing it. Mirror it, but don't just mirror it, understand it.
So in the same way that U.S. companies had to become GDPR compliant because they had a global audience, which involved Europeans, on the international level, Europeans or anybody else in the world that has a global activity that involves Americans, specifically Californians, but this is going to rapidly spread into other laws across the country that will adopt similar privacy acts in similar ways. Potentially not as strict, but still similar. This is something that companies around the world that have American users of their service, American clients in any way, that they need to make sure that on top of their GDPR compliance, they are ticking the boxes of CCPA.
Absolutely, couldn't have said it better myself. And I think, just to add on to your point, you have to understand as both a consumer and a business owner that you're never going to be able to track every single client or customer, every transaction. You have to generally know who and where you're conducting business. And within the state of California, this CCPA is a framework. It is a groundbreaking privacy law that is going to set the standard for the United States. Is it perfect? No. It is a starting point, and we already have states that are trying to simplify even more the CCPA. We have New York right now. We're in Ohio, but we have New York right now that's already working on its own privacy laws, and actually has been working to try and implement its own privacy law before January, before CCPA, to kind of beat that. Ohio is working on its own. States like New Jersey and Washington, they're already working on their own variations. But what are they using for guidance? You bet they're looking at the CCPA and saying, what do we like? What do we don't like? What do we want more clarification on? And also GDPR.
But as it says,
yes,
own your data.
And it's heavy. This is
Yes.
heavy. Thank you, Brittany Kaiser.
Own your data. Understand
Protect it.
that no matter where you are based and who you think is using your services, there are most likely Californians in there somewhere. So CCPA matters, and even if you think that's not the case,
Doesn't
this
matter.
will rapidly be an American issue involving many of the more populous states, and that's just something that needs to be taken into consideration globally.
It's so much. Why not comply? Don't ever assume. It just doesn't work. But yes, this is a start for states to really get their stuff together. And it's for our protection. It's not against us. It's to protect us.
Excellent. Well, I appreciate your time. Thanks for informing us about CCPA, and I have a feeling this is going to be something we're going to come back to a bunch more next year as well. So as that gets clearer and as we have some other states come out with stuff, I think we'll come back to Drew to talk more about that. Thanks.
Thank you, Ethan, very, very much. It was a pleasure.
Thanks,
Thank
buddy.
you, guys.